Yeah, he's making it right now.
Everybody ready?
All right, please be seated. I have a note from the jury which I will read. To the judge, we, the jury, after further deliberation, still cannot reach a unanimous verdict. Let me just make sure everyone confirms for the record what I must do. State agree I must declare a mistrial at this time. Yes. Defense? Yes. All right, so defense agrees I must declare a mistrial. Okay, what I'm going to do is bring these folks out. I'll go ahead. On the record at this time, I'm now declaring this case mistried by virtue of the fact that the jury cannot reach a unanimous verdict. I'm going to bring out the jury. I'm going to discharge them, and then we'll talk about logistics for just a moment, okay?
Are you willing to poll the jury?
Here's what I'd be willing to do if you're curious. I didn't think you would be in a case like this, but I've done this in other cases, both civil and criminal. What I'm willing to do is I'm not going to have anyone state on the record what their vote was. What I am willing to do, if the parties are requesting it, and if there's no objection, is I will send back 6 verdict forms in blank. I will ask them to check off how they would have voted without putting their names on it. I will then collect those up and share them with the parties if you wish. I've done that before, but I'm not going to have them declare in open court how they intended to vote.
That's very good.
Is there any objection to that from the state? Okay. So what I'll do then, it's going to be a 2-step process. I'm going to tell them that we've declared a mistrial. I'm going to ask them to do this favor of me. I need to get 6 copies of the verdict form. I wasn't prepared for this, so I'll need to... I can handle this. Hang on. Just take that. All right, where's Castrodakis' printer? Okay. Okay, what I will do is I will ask them to fill them out without their names. They will be turned in back to me, and then after I've discharged them, if you like, I'll either give you copies or I'll publish the results, one or the other. Agreed?
Yes, Your Honor.
Okay. So first thing I have to do is get them to fill out this verdict form for me, so bring them out. I need to give them instruction. I don't want to just do it blindly.
Jury entering.
All right, counsel may be seated. Welcome back, ladies and gentlemen. Understand that you were not able to reach a unanimous verdict, so I have declared a mistrial in the case. I'm going to ask you one favor before I discharge you, and I'm going to send you back in to perform this favor in just a second. I'm going to give each of you a blank verdict form, same verdict form that you had back in the jury room during your deliberations. What I'm going to ask as a favor, and I'm not going to order you to do this, I'm not going to compel you to do this. This is just a request from the court for our assistance going forward. What I'm going to ask you to do is to check how you would have voted or how you did vote in connection with the verdict, but do not put your name on it. In other words, we do not want to know who voted how, etc. All we're trying to figure out is how many votes this way or that. That's the whole purpose of this exercise, frankly, and it assists the parties going forward. So I can't order you to do that, and so if I get 4 back, that's fine. If I get 6 back, that's great. It's a request. That's all it is. But please make sure you don't put your name on it. All we're looking for is you've got 2 choices, guilty or not guilty. We'll each give you a form. If you'll just check off how you would have voted without putting your name on it, I'm going to bring you right back out, and then I'm going to tell you what we're going to do next in terms of your discharge. And when you've done that, just knock on the door when everyone's had a chance to do that. All right, maybe see. Let's just give them a couple. This shouldn't take very long. Brianne, here's the last note. Okay. All right, we'll deal with this later. Can you just go ahead and ask him to come in?
Okay. Jury entering.
All right, counsel, you may be seated. Welcome back, ladies and gentlemen. I do appreciate that favor that I asked. It looks like I got 6 back. I do appreciate that. That's helpful going forward. As I've indicated to you already, I have declared a mistrial because you've not been able to reach a unanimous verdict. I just want to say a few words before I let you go. First of all, I do want to sincerely thank you for the time and energy and participation in this case. It's been a long case since jury selection all the way through trial. You've been in deliberations for 7 or 8 hours. You've tried very hard to reach a unanimous verdict in this case. Because you've not been able to do so, you should not in any way feel critical of yourselves. All jurors must vote their conscience in any case, and that's what we look for jurors to do. And so the fact that you were not able to reach an unanimous verdict does require a mistrial, but you should not think that that reflects in any way poorly on you. You've done your job. You've been here. You've listened to the evidence. You've done your best to reach a verdict. You simply have not been able to agree. Going forward, when I release you, you need to understand that you have certain privileges, okay? You have a privilege not to speak with anyone concerning your jury experience, including the deliberations, the discussion, or the vote which occurred in the jury room. In other words, absent a court order, you cannot be compelled to discuss those matters which occurred in the jury room. You may be approached by people who are curious about your experience in the jury room and may want to speak with you. Whether you speak with those folks or not is completely up to you. Keep in mind, it's like your notes. It's a privilege that you hold. You have to decide whether or not to waive that privilege or not. And so if you do not wish to speak to anybody about your jury experience, you simply tell them, I do not wish to speak. If you wish to speak, you are free to. It is completely up to you. Just keep in mind, it's your privilege to waive. In front of you, you should have certificates of appreciation. It's a little bit anticlimactic because that you saw when I discharged the alternates, I told them you get a certificate of appreciation. I'm sure you'll all frame it and hang it on a wall somewhere. It's simply an appreciation certificate signed by the Chief Judge of the 15th Judicial Circuit, the Honorable Jeffrey Colbath. One thing I did not speak about is you will find attached to the certificate a questionnaire. For lack of a better way to describe that questionnaire, it is a report card on me. It has to do with the manner in which I conducted the trial. You are not required to fill out that questionnaire and send it back in. There is a stamp, though, provided for you, or envelope and a stamp, hopefully, where if you do choose to fill out the questionnaire, you can send it back to us. Although you're not required to, we do like to get as much input as we can to improve things as best we can. So if you want to make any comments, please go ahead and put them on the questionnaire and send the questionnaire back in. If you do choose to do that, please don't put your name on it, and please, again, don't put anything on the questionnaire concerning the deliberations, discussion, or the vote which occurred in the jury room. I've already indicated that's a private affair unless you decide to waive that privilege. And so it's up to you as to whether you want to speak with other people, but I'm certainly not on the questionnaire looking for any kind of feedback with respect to the discussions, the deliberations, or the vote. Just the manner in which I conducted the trial and any other comments that you might want to give us to improve the process. That's what we're looking for, essentially. So with that said, again, I appreciate your service in this case. I'm going to discharge you now with our thanks. The deputy will take you out back through the judicial hallway as usual. Have a pleasant week and a safe drive home. All right, counsel, you may be seated. I guess let me deal with the polling first. Do you guys want copies of this? Do you want me to just announce the results? What do you want me to do?
Copies.
Copies, okay. You do not want me to announce the results in an open court? I'm pretty certain that once I release these to the lawyers, everyone's going to know about it.
You can announce it.
So I'll just tell you, it was not a single holdout. So, concern about there being pressure, I guess, was not founded. By my count, there were 3 votes for guilty and 3 votes for not guilty. I'll be happy to make copies of these for you so that you have them, but it was actually a 3-3 split according to what I got back. Okay, let's deal with a couple of things going forward. Obviously, I need to set a status check in the future so that we can discuss how it is that we're going to proceed in the case. What I'm proposing is to set a status check either January 3rd or January 6th at 1 o'clock for just a couple of minutes to decide what to do next in terms of proceeding again to trial. Any preference between the 3rd and the 6th by either side? January.
I'm getting married in the middle of January, and I don't want to run the risk of what happened in this trial.
Are you going to be out on the 1st or the 6th?
The first through...
It's the first week of January.
Your Honor, anyway, I respectfully can do
The 3rd is the first week. I probably can, but then it's going to probably run into Mr. Rosenfeld's wedding.
Pushing into my wedding, can we just start in February or March?
Well, I'm not going to push it out to March. I got to have a status check.
Status check in January.
Can we do early in the second week of January?
Yeah, all I'm doing is it's a 10-minute status check. I'm not resetting the trial. I have to decide what we're going to do, where we're going to try all those issues. But all I want is I have to set a future event, as you know, just to make sure the case doesn't fall off the docket. So all I was going to set is like January 6th at 1 o'clock, or January. Let me hang on. Get to the right month. January 3rd is a Tuesday. January 6th is a Friday. And Mr. Claypool, I don't care if you appear by phone. That doesn't make any difference to me. It's a status check. It's just where are we going next? That's all it is.
The 6th would be preferable.
Friday?
Yeah.
All right, so Friday, January 6th at 1 o'clock, we're going to set a status check, and I'll decide what to do next in terms of scheduling. And Mr. Claypool, if you wish to appear by phone, just let us know in advance so I know that, so I can hook you up. Okay. All right. I do have one other question or concern, and it's not out of mere idle curiosity. I have to ask Mr. Claypool a question concerning a statement he made in his closing. At the end of your closing, Mr. Claypool, you indicated, among other things, that Ms. Dippolito should be sent home to her family and infant son. I have got a couple of questions about that. Obviously, there was an objection, a well-founded objection. It was basically a plea to a motion. It also put facts, not evidence, before the jury, but that was handled with an objection, which I sustained. What I'm concerned about is that normally, I've had defendants have a child while on house arrest. There's nothing about that per se that's a problem, but normally there are orders in the file concerning permission to go to hospitals, prenatal care, postnatal care. I don't recall seeing any of that in this. Was that handled in some way?
I dealt with that, Judge. She is permitted to, on house arrest, to go to any medical appointments or hospitals, and due to HIPAA regulation, she's not required to tell house arrest why she's at the hospital.
That's true. That's true. So I guess my question is, was that an accurate statement?
Yes, it was. I personally dealt with house arrest to let them know she was going to the hospital. There was no lies about that.
No. I'm not worried. I'm not going. But that was an accurate. It was an improper statement. But I sustained an objection. But it was an accurate statement.
Yes, Judge. It was an accurate statement.
Okay, that's what I want to be concerned about. I just want to make sure, in addition to it being objectionable because of the grounds I've already set forth, that it was in fact accurate, because you wouldn't be able to tell that from the record in terms of the hospital visits. Okay, we have a status check set on January 6th. Is there anything else we need to do at this point? Defense?
No, I'm speechless. No one should.
You don't want to object?
Judge, I put a smile on your face, so I guess I see it in that sense.
Your Honor, I would like to mention I do appreciate the court's, I really appreciate the court's diligence in making this happen. I know it was a roller coaster ride, but we do appreciate the court's commitment to seeing this case through. Thank you.
Okay, well, I guess I get an opportunity to do it again. Mr. Williams, Ms. Laurie, anything from the state's perspective I need to do at this time? Okay, we are in recess until, what did I say, January 6th? All right. Oh, you have to sign, I'm sorry, Ms. Dippolito, you have to sign for that date before you leave. Attorneys want copies of these mock verdict forms? Yes. Mr. Rosenfeld, you want copies of this? Is 2 sets okay? One for state, one for defense? Yes. All right. Neil, can you do that for me? One apiece, one for defense, one for state. No, I don't care. That's just for their purpose.
died?
Yeah, I think